Hello everybody. Today's session is going to be about the Doctrine of Judicial Precedent, which is chapter 5 of the module guide. So the judicial precedent is basically the idea or the concept which supports the notion that the judges would be bound by the decisions that are made by the judges previously. Now there are two kinds of judicial precedents, vertical and horizontal. When we refer to the vertical judicial precedent, we are referring to a higher court making a decision and then the lower courts being bound to follow the decision made by the higher court. This is known as the binding precedent. As the name says it all, it is binding on the lower courts. The lower courts are bound to follow it. They do not have a discretion as far as the case facts are similar and non-distinguishable. However, there is another type of judicial precedent which is known as the horizontal judicial precedent. This happens when the courts in the same level of hierarchy make a decision. For example, a judge made a decision in the high court, another judge in the high court, same level of hierarchy, no vertical precedence, horizontal precedence. This is when the precedence is not binding in nature but persuasive. As a lawyer, you can refer to the high court decisions in the high court. I'm sorry. However, these would not be binding on the judge. These will be, say, persuasive. Again, when there are two courts in the same level, and say this person had a case very similar and identical on the basis of facts to this person, and this person has already decided the case, right? So then person A can use that judgment from this court in this one. However, this court, since they are both in the same level of hierarchy, this court will not be bound to follow this court's judgment. However, it can be persuaded by it. That's all about the principle of judicial precedent. Now, why is it important, the concept of judicial precedent? Because it promotes fairness, coherency, consistency, and justice. How does it do it? If I take my matter to the court and the court decides to give me 10 years of sanction in jail, punishment in jail, another person with the similar case or similar facts, if his matter is taken to the court, then he should also be penalized for 10 years, not 20, not 5, because then it would be unfair for me or unfair for him. That is how it is important. Another point, why is it so important? Because sometimes the courts take as long as 2 years, 3 years, if not longer, to decide on a legal complexity. When that legal complexity has been decided, the other following cases dependent upon that specific legal complexity would not have to litigate argue the matter over and over again for another couple of years or if not more. They can just refer to the judicial precedent that was said before in the similar context, similar legal complexity, and the court would be bound or at least persuaded to follow it. Then we talk about what part of the judgment do we use as a judicial precedent. The judgment is very long. Sometimes it can be 20 pages, 50 pages, as much as 250 pages if not more. The judgment, why is it so long? Because it covers all the facts of the case, it covers all the arguments by the parties, it covers all the evidentiary values, it covers all the witnesses' stances and statements, it covers all the reasoning that the judges applies to decide a case, and then it gives the decision of the case. So the only important bit that is significant for a judicial precedent comes from the part of the judgment that is known as the ratio decidendi. Ratio decidendi literally translates from Latin to English as reason for deciding. Ratio decidendi is the rationale behind the decision. And then obiter dicta is another term which is a part of the ratio decidendi. Obiter dicta is again the Latin term, and it translates specifically to decisions or things said by the way. Obiter dicta does not have a lot of impact on the judgment or the decision made by the judge. However, both of these things, ratio decidendi as well as obiter dicta, can be used for judicial precedent purposes. Right. Then we move on to the ways in which a case can lose its binding authority. So a parliament can expressly just say that this specific case is not binding in nature because of any reason whatsoever, or a parliament can impliedly overrule a case by changing the law through making a statute, because the law is now different. The previous law and all the cases that were decided upon on the basis of the previous law will not be binding in nature. Then reversal is another way in which the cases can lose their binding authority. Reversal refers to, for example, a court decides the matter against me. I decide to take my matter to the appellate court and I appeal it, and the appellate court decides the matter in favor. So the court that decided the matter against me, that decision, that judgment will not be binding anymore because that has been reversed by the appellate court. Then the third and the final way in which the cases can lose their authority is through overruling by the courts themselves. For example, the city court judge decides a matter, and then the higher court decides that the city court judge did not decide the matter properly, or he just decides the similar matter about the similar case facts in a different way, which is contrary to the city court's decision. Then that is how the decision made by the city court will be overruled by the higher court. Then the chapter 5 talked about judges making law, and we talked about whether or not do judges actually make law. So first of all, in theory, judges do not make law. It's the parliament that is supposed to make law. The only body of the legal system that has the authority to make law is the parliament. The parliament makes changes, amends the law. The judges only interpret the law or declare the parliament's statutes. That's what the idea in theory of a legal system is. However, in practicality, there are many times when the judges have been seen as making law in itself. For example, the case of R against R, when the judges changed the 250-year-old rule or law on marital rape. Marital rape was legal. However, the judges chose to make it illegal because of the changes in the society. Again, there was no parliamentary act or no statute stating that it would be illegal. However, judges decided to do so. They made a new law. Again, on the other hand, R against Brown is another case which deals with the time when the judges made law. This is the case about the masochism. In other words, it is bondage, where it was about homosexual a couple, and the courts decided, because it was unique, there was no parliamentary statute on it, there was no act on it. The judges decided the case on their own. There was no judicial precedent. Hence, it can be said that the judges made a new law. Now, once you establish that the judges make law or they only declare law, you can come down to the idea of whether the judges should make law or not. If you say that the judges should make law, you should argue that because the parliament makes acts which are made after a long process, for example, passing the green paper, then the white paper, and then drafting it, and then enacting it, judges can address the matters of urgency by making law. For example, R against R. The parliament never made a law on it, probably because it was taking it too long. But since the matter required urgency, the judges decided the matter on their own and did not wait for the parliament. Hence, the matters of urgency can support the idea of the judges making law. On the other hand, if you say that the judges should not make law, then you can always argue that because judges are not elected, they are appointed, they should not make law, because then it would be undemocratic. Alright, that's all about it. And then chapter 5 was covered all of that only. There were a lot of case laws, there were a lot of quotations mentioned in the guide. For better understanding, for more details to put in the answer, you guys should refer to the chapter 5 of the guide. These lectures are only designed for you to review and revise in a very short span of time. Thank you.